5 things you must know before the police serve a search warrant. Hi everyone, welcome back. Today we're talking about something that could happen to anyone. Having police show up at your door with a search warrant. Whether it's state police or federal agents, if you don't know your rights, you could end up making things worse for yourself. I'm going to walk you through 5 critical things you need to know about search warrants in Texas before law enforcement ever knocks on your door. Let's get into it. It starts with an investigation. The first thing you need to understand, if the police are serving a search warrant, there's already been an investigation going on, possibly for weeks or even months. Here's how it works. Some law enforcement officers, could be local police, a sheriff deputy, FBI, DEA, whoever, starts to suspect criminal activity. Maybe it's drug trafficking, money laundering, healthcare fraud. It doesn't matter. They start digging. They talk to people. They gather statements. They watch for suspicious behavior. And they're building a file, trying to establish what's called probable cause, a reasonable basis to believe a crime has occurred and that evidence exists in a specific location. Once they think they have enough, they draft a sworn affidavit. This isn't just a casual conversation with a prosecutor. This is a formal document under oath that lays out all the reasons they believe evidence will be found at your home, in your car, on your phone, wherever. Then they take that affidavit to the judge or the magistrate. If the judge agrees there's probable cause, they sign a court order. That's your search warrant. This order commands law enforcement to search for specific items and seize them. In Texas, once that warrant is signed, they usually have 3 days to execute it. The clock is ticking. Bottom line, you can't just have police barging into your life without following strict legal procedures. If they cut corners, lie in the affidavit, or fail to establish real probable cause, your defense attorney may be able to challenge the entire warrant and get the evidence thrown out. Search warrants have strict requirements, and if law enforcement doesn't follow them to the letter, the warrant can be invalidated. First, timing. Under Texas law, most search warrants must be executed within 3 days of being issued. There are exceptions like DNA warrants get 15 days and warrants for electronic data get 10 days, but generally it's a 3-day window. The warrant also has to be properly documented. It needs to identify the state of Texas, the name of the judge or the magistrate who signed it, correctly identify you or your property, and specifically describe the place to be searched. And get this, if they seize a computer or phone, they have to physically grab it within that time window, but they can analyze the data later. So even if they took your phone 3 days after the search warrant was issued, they're still technically within the rules as long as they grab the device in time. Here's what you need to know. You have the right to see that search warrant when they show up. They're supposed to leave you a copy along with an inventory of everything they took. And if they don't, surprisingly, there's no automatic consequence. You won't get your case dismissed just because they forgot the paperwork. But here's what matters. The affidavit behind the search warrant, that's the document that explains why they had probable cause. And you will not get a copy of that at the scene, but your lawyer can get it later, and that's where we can find the problems. You have constitutional protections. Number 3, and this is huge. You are protected by the 4th Amendment against unreasonable search and seizure. Both state and federal law, along with tons of court precedent, give you serious protections against government overreach. The 4th Amendment says the government can't violate your privacy without probable cause, a sworn affidavit, and a warrant that specifically describes what they're searching for. Here's where it gets interesting for your defense. Remember that affidavit I mentioned? If your lawyer can prove that the affidavit contained lies, exaggerations, or major gaps in logic, we can file what's called a Franks motion. If the judge agrees that law enforcement made false statements either knowingly or with reckless disregard for the truth, those lies get tossed out. And if what's left doesn't add up to probable cause, the entire search warrant becomes invalid. That means everything they found gets suppressed. The prosecutor can't use it. There's also something called the Four Corners Rule. Probable cause has to be clearly established within the four corners of that affidavit. The judge can't just assume facts that aren't written down. So while it's terrifying to have agents at your door, just know you have rights, strong ones, and a good defense attorney knows exactly how to protect them. One warning though, I get it. This situation is incredibly stressful. You might be angry, scared, or both, but do not interfere with officers. Even if you think they're doing something wrong, stay calm, take mental notes, save it for court. If you ask, am I being detained or can I leave? And they say you're free to go, leave. If they say you're detained, that's when you say, I want my lawyer. What do you do when they show up? Number 4, how to behave when the warrant is actually served. If you even suspect you might be under investigation, don't wait. Get a criminal defense lawyer involved now. We can sometimes coordinate with law enforcement ahead of time, which makes everything go smoother. But if they show up unannounced, here's what you need to know. You have the right to see the search warrant. They're supposed to show it to you if you're present. They can only search what's described in the search warrant. If the warrant says they can search your car, they can't search your neighbor's car or your mom's car unless it's specifically listed. They may ask for your consent to search outside of the scope of the warrant. Politely say you need to speak with your attorney first. Everything they seize must be listed on an inventory, and each officer must sign their name next to the items they took. You have the right to a copy of that inventory when the search is done. If you're not home when they execute the warrant, they're supposed to leave both the warrant and the inventory for you to find. But if they don't give you a copy, it's not a legal defense in your case. If they arrest you during the search, exercise your right to remain silent. Do not make any statements, not even small talk, until your lawyer is present. I know it feels rude to stay quiet, but trust me, it's the smartest move you can make. Your lawyer can challenge the evidence. Search warrants are often the backbone of a criminal case. If law enforcement seizes evidence and it's tied directly to charges, that's a strong case for the prosecution. But if there are flaws in how that search was conducted, your defense attorney can get that evidence suppressed, and that can change everything. This is where something called fruit of the poisonous tree doctrine comes in. It's a legal principle that says if the government obtains evidence illegally, then anything that flows from that illegal search is also tainted and can be excluded, no matter how damaging it is. Let me give you a real example. There was a case in Texas called St. George versus State. Jeffrey St. George was a passenger in a car that got pulled over for a broken plate light. The driver gave her information, but the deputies kept demanding Jeffrey's name and date of birth, even though he wasn't driving. He refused, and they arrested him for it. During the arrest, they found marijuana in his pocket. His lawyer appealed, and the court agreed. The deputies had no legal right to demand his ID. The arrest was illegal, and because of the fruit of the poisonous tree doctrine, the marijuana evidence was thrown out. The case was dismissed. That's the kind of defense work that can make or break a case. Every search warrant has to be examined with a fine-tooth comb. Was the affidavit truthful? Did they follow procedure? Did they stay within the scope of the warrant? Did they have probable cause in the four corners? If the answer to any of those questions is no, we can file a motion to suppress. And if the prosecution can't prove their case without the suppressed evidence, you could be looking at reduced charges or even a full dismissal. Remember, you have rights, constitutional protections, and a good criminal defense attorney who knows how to use them. If you found this helpful, hit that like button and subscribe for more real-world legal insights. And if you or someone you know is facing criminal investigation or has already been served with a search warrant, don't wait. Contact an experienced criminal defense lawyer immediately. Thank you for watching, and I'll see you on the next one.